Again, the next case on our docket is Jamie Jarausch versus Christine Weaver. Counsel, if you're ready, you may proceed.
May it please the court, my name is Preston Auden. I represent appellant Jamie Jarausch. I would like to reserve 5 minutes at the conclusion of my arguments for rebuttal. May I also present the very real $64,000 question. This case involves a default final judgment in the amount of $64,000. And in the initial brief, I break down appellant's arguments into 5 separate areas, but for the sake of brevity, I'm going to break them down into 3 categories for today. And those categories or topic areas are based on 3 questions. Those are, was the motion for relief timely filed for either the clerk's defaults or the default final judgment? And if this honorable court agrees that the motion for relief was not timely filed for either the clerk's defaults or the default final judgment, then the order granting relief for both must be reversed, and this court need look no further than for the remaining arguments.
Counsel, before you get to your second point, like I did in the last argument, facts matter, and I want to make sure I understand the facts. So we have a complaint that is filed and served on Christine Weaver and Christine Weaver Trust, correct?
That's correct. They are the appellees in this matter.
And on July 6th, the clerk of the circuit court, 4th Judicial Circuit, enters a default against Christine Weaver and another default against the Christine Weaver Trust, correct?
That is correct, Your Honor.
And then approximately a year later, you file your motion for ex parte motion for default final judgment, correct?
Against the appellees, correct, Your Honor.
And it's predicated upon those clerk's defaults.
Correct, Your Honor.
And then about 3 months later, Judge Norden grants your client's motion.
On the default final judgment, based on those defaults, Your Honor, yes.
My concern, Mr. Auden, is we have an amended complaint here. And we have an amended complaint that was filed in October of 2016. There was, am I correct, there was never a clerk's default on the amended complaint?
There was not, Your Honor. The amended complaint changed count 4 as it pertained to Hayward construction and altered not at all counts 1, 2, or 3, which were the breach of contracts, negligent misrepresentation, and fraudulent misrepresentations that only applied to the appellees.
And I understand that to be in the record, consistent with what you just verbalized. My concern about the amended complaint is the long line of cases that say that the amended complaint supersedes the initial complaint. And is that your understanding of the law as well, that an amended complaint supersedes the initial complaint?
It does, Your Honor, and I would add to that the prior default under the existing complaint and those cause of actions that were unchanged would not affect the superseding nature of the complaint as to the parties who were defaulted.
I think that may be our issue here.
Okay.
And whether that initial complaint then becomes a nullity. And we're traveling under the amended complaint, and thank you for being so candid on the record. We don't have a clerk's default as to the amended complaint, and as I read the final judgment entered by Judge Norden, it was predicated upon your motion that didn't reference the amended complaint. Is that your understanding?
It could have just been nomenclature, Your Honor, in that whether it references, large C complaint as a defined term versus large A and C amended complaint as defined terms. It would have been on the 3 causes of action alleged in both. The same 3, as well as the same allegations as to the appellees alleged in both. And so I guess the argument here, if I'm understanding what you're asking here, Your Honor, is do those same defaults on those same 3 counts also translates to the same 3 counts and the same allegations in the amended complaint? And My understanding is that they do. I don't know that that was ever argued at the trial court level. I'll be honest, I wasn't necessarily prepared for that argument today, but I'm happy to the best of my abilities to answer your questions.
And thank you for being gracious in that regard. And I didn't see that argument advanced, but as you know, one of the ways we can affirm what a trial court has done is if they did the correct thing for the wrong reason. And so when I first looked at this file, I saw amended complaint, and it just concerned me that there was not a clerk's default or a motion based on that amended complaint. So it would, just so I understand, it would be your position that those predecessor clerk defaults as to the 3 counts would carry over to the amended complaint?
That's my understanding. I'm not sure the protocol for this, but if I were in trial court, I would say, Your Honor, could I have the opportunity to brief that and get it back to you? I'm not sure if that's available as an option here, since it wasn't argued at any point before today.
And I appreciate your candor in that regard, Mr. Alden. If, in fact, it did supersede the initial complaint and the initial complaint became a nullity and thereby mooted the clerk's defaults, you would agree the whole basis behind the final judgment would be nullified?
Without having done any further research on it, it would seem so, but at least under the relation back doctrine, it would be I would be hard pressed to fully agree here and say, yep, that's great, let's go back to the trial court and relitigate this entire issue. The issue that we had here, and if I could just briefly do some recitation of facts, the appellees in this case, one of which is a trust, the trustee of the trust being Christine Weaver, filed an affidavit with the court saying we took a wait-and-see approach. At the point we initiated collection process of the default final judgment is the first time that Ms. Weaver came to the court asking for relief for it to set aside. It would seem that 2 years into the litigation, more than a year after the clerk's default was entered, there would be some public policy argument that that's not a reasonable amount of time to ask for a set aside of a default.
Let's talk about that issue, well, maybe the issue that was the first part of your statement, and that is whether it was appropriate for Judge Norton to enter the final judgment based on the motion as advanced. Part of that motion depended upon an estimate of the damages in this case. Would that be the type of evidence that you would present to a jury, an estimate of damages?
Well, the estimate would have to be corroborated by testimony from whatever expert that issued the estimate. So in this case, I think you're referencing Exhibit D to the complaint.
Correct. Which
is an estimate from a contractor. In a trial, I would have to tender that witness, and they would have to proffer testimony as to what that estimate represented as far as damages. It's my understanding, and that kind of goes to my third argument, which is talking about liquidated versus unliquidated damages, if I may. I think that falls under that Dunkley-Stucco 5th DCA case that was referenced in both briefs. And essentially under that case, again, setting aside for a moment the fact that the court is considering whether the default on the amended complaint was proper or not, assuming that fact to be true, if a defendant admits that the amount claimed, I'm quoting from the case here, Dunkley-Stucco, that the amount claimed is due, whether by general admission or by default, he, quote unquote, determined it and is not thereafter entitled to a hearing to require plaintiff to again establish the amount to which defendant agrees he is liable. I think your question is whether the estimate was sufficient evidence in order to determine the amount due, and appellant's argument is that that's what was specifically pled in the complaint. There's no evidence refuting that fact. In fact, if there's the clerk's default that stands, then it's admitted as a fact, and that's the only amount that was sought in the default final judgment. They changed not at all between the complaint, amended complaint, and default final judgment.
But was the amount sufficiently definite and final?
I think that's a great question, because I think counsel, highlights, there's a case that he highlights, that's the Pierce case, that talks about whether the language that follows the $64,000 is enough for this court to say that it wasn't final in its calculation. The language that follows, and I'm going to quote from the amended complaint here, states, the $64,000, not including attorney's fees, cost, and loss of use of a portion of the property affected by the defect. All of those damages are ancillary to the $64,000 damages. And so as a strategy, the plaintiff in this case, or any case, could abandon any additional damages that are ancillary to the total amount of damages sought under the complaint, which is the $64,000. So I would distinguish those two cases, Dunkley from the Pierce case, in saying that those damages were ancillary and that the $64,000 which was sought and entered into as a default final judgment was the specific amount sought under the complaint and travels under that Dunkley 50 CA case.
There was an attachment to the complaint, in the amended complaint, was the purchase and sale agreement. And in that purchase and sale agreement, which you agree would be subsumed within the pleading and would actually trump the allegations of the pleading, there is a statement in the purchase and sale agreement saying, that says that each party will bear their own attorney's fees and costs. So again, the complaint sought attorney's fees. Wouldn't that nullify that as being a potential element of damage, and would be another reason that this final judgment of default should not have been entered?
I don't believe so. Again, Your Honor, they're ancillary to any damages that are alleged in the complaint, and the default final judgment does not award attorney's fees and costs. The right to plead attorney's fees and costs are obviously based on statute or contract, and if they're not found in a statute or contract, they're not appropriate to award, and plaintiff didn't seek them in this case. They just sought the $64,000. I would like to reserve the remainder of my time. Thank you.
Good afternoon. My name is Paul Aiken, spelled E-A-K-I-N. I'm of the law office of Nancy C. Harrison. I'm here on behalf of the appellees. Judge Jay, you raised a very interesting point. The one that I'm embarrassed was not raised in the lower court nor in the briefing of this appeal. And quite frankly, like opposing counsel, I do not have a concrete answer for the panel, and I apologize. But be assured of one thing. The amended complaint had attached to it Exhibit D, which was a proposal. And that proposal is dated in March of 2016. And that proposal was not attached or used in the entry of the judgment. An affidavit by the plaintiff was used in the entry of the judgment. There's a leap of logic on all of our parts that it was the affidavit statement is based on that proposal. The proposal itself is dated in March of 2016, to Judge Jay's point about time. The judgment is entered more than a year and a half later. The fine print on that proposal says, and I quote, "The contractor reserves the right to withdraw this proposal if not accepted within 30 days of the above listed date." To use a proposal to base an affidavit on when the proposal is more than a year and a half old as the foundation for your damages in a default case is not a tenable position in the state of Florida.
Just to make sure I understand, Mr. Aiken, and I think I do understand what you're saying, there is a fuse on this estimate saying 30 days, and we're well past the 30 days at the time of the motion and the final judgment, correct?
That's correct, Your Honor.
And on top of that, we have an estimate. We don't have someone saying that this is a definitive number, correct?
There's no one saying that, Judge. There's no one saying that.
So your point as to that, setting aside the amended complaint issue, would be that was a deficiency in the final judgment that required Judge Norton to set it aside.
I mean, I accept the fact, I've done this job for 39 years. I've been a trial lawyer my entire career. And I'm not here to suggest to this panel that I haven't walked in after a clerk's default has been entered with my own motion for entry of a default judgment and submitted an affidavit to a trial judge and not have the trial judge review the affidavit the way it is reviewed in the context of a motion for relief. And I don't expect a trial judge to do that. Their time is way too valuable. I don't expect a trial judge to review the complaint or the amended complaint to see if causes of action are stated. That's not their concern at that stage of the proceeding. It is only when a motion for relief from judgment is filed and those safeguards are put in place for the litigant does the trial judge then have the responsibility to go back and look closely at the pleadings and the affidavits that were submitted to them whenever. And that's what happened in this case. And when a trial judge sets aside a voidable judgment, that is a matter of judicial discretion. It is not the same judicial act as setting aside a void judgment, which is reviewable de novo. I think Judge Norton was eminently correct in setting aside the judgment in this case. You would expect me to say so. I understand that. But there were so many fleas on this dog, if I can borrow a colloquial saying from my hometown, that I think she had very little choice but to set the judgment aside.
What about the argument that the motion was untimely? How do you
Absolutely
respond?
incorrect, Your Honor. I'm glad you brought that up. As we have pointed out before the trial court, and we have pointed out in our briefing, and I know I made short shrift of it in the briefing, but it really deserves short shrift treatment. Under Rule 1.540B1, the mistake, inadvertence, and excusable neglect of that rule, those motions have to be filed within 1 year of judgment. That's what the rule says. I'm quoting verbatim. The judgment here was entered in October of 1 year, 2017. The motion was filed in February 2018, 5 months later. We are clearly within the 1 year limitation set forth in Rule 1.540B1. We have never argued before the trial court or before this court that that judgment was void and therefore subject to Rule 1.540B4. Those motions can be filed at any time, because they are based on the fact that the trial court did not have jurisdiction, and therefore any act coming out of that court is a nullity, is what the case law says. Those judgments can be attacked at any time. We have never argued that our case proceeded under that part of the rule, just so we're clear. It's the old voidable versus void, as I like to say. I could take up more of your afternoon, but I really don't see any reason to. I stand by my brief. I appreciate your time. Thank you for having us in this afternoon.
Thank you, counsel.
Well, I would also like to talk about void versus voidable, so I'm going to take a few moments just to do that. Counsel's right, and it seems like the parties agree that this is not a void issue, it's a voidable issue. And so if that's true, then the 1 year requirement on setting aside of a clerk's default would still apply to the clerk's default for the original complaint. Whether this court finds the amended complaint extended that out or not, that clerk's default on the original complaint is still live and exists as we talk here today. And therefore, appellate does not believe that the trial court had the jurisdiction to set aside that clerk's default more than a year under 1.540B1 as pled in the motion and as pled in the answer brief that's filed before you. And so I just want to talk about that for a moment as it relates to the other 3 points that I wanted to discuss.
And that issue would be solved if, in fact, the amended complaint superseded the initial complaint and mooted those defaults, correct?
Again, I don't know because I've not briefed that issue.
But assuming that was the law.
If that's the law, then I have no argument against it because I don't know what the law says as to that specific issue. Nonetheless, none of that was argued at the trial level, and nor was the timeline for the proposal for the estimate in Exhibit D argued at the trial level. But just assuming for a moment, setting aside that that could be, and I'm not arguing with you, Judge Jay, I'm just saying that that could be the law. If in fact it's not, it looks like to me that the Florida Supreme Court has already ruled on this issue of defaults and how they have effect as far as timeliness on defenses once you get to the final judgment stage. And that is the Bank of New York Mellon versus Condo Associations of Lemur Estates, Inc. It's a 2015 Florida Supreme Court case. And what the Florida Supreme Court in this case held is that if a party is properly notified of a pending proceeding, that party has the opportunity to raise a defense, such as a failure to state a cause of action under 1.140B, in an answer or a trial or at any time prior to a final judgment, then that defense is deemed waived if not timely made. In other words, if a defendant waives their right to raise a defense, such as failure to state a claim, unless they do so prior to the entry of a final judgment or in a timely post-judgment motion or appeal following the entry of a judgment, then as here, they've waived the right to raise it after the final judgment is entered, if not done so timely within 30 days of that final judgment. Thank you, Your Honors. I appreciate your time today.
Thank you both. This court will stand in a brief recess for coffee in the rotunda.
All rise.